Fantastic.
Okay. Sheriff Supke, raise your right hand. Swear the testimony you're about to give will be the whole truth and nothing but the truth, so help God.
Yes, I do.
All right, are you ready?
We're ready.
Great. Mr. Zupke, can you say and spell your name, please?
Brian Zupke, B-R-I-A-N. Last name Zupke is Z as in zebra, U-P-K-E.
All right. And are you employed by Ashland County?
Yes.
In what capacity?
As sheriff.
Okay. And what were you before that, if anything?
Deputy.
Just a deputy?
Chief deputy.
Chief deputy. Okay. And from what period of time were you the chief deputy?
For approximately a little under 2 years before I was sheriff this year.
And when did you become sheriff?
This year, 2023.
I think the date might be important here. Are you able to say what date you became sheriff?
January 3rd.
Okay. And do you know Kim Lavasseur?
Yes.
How do you know her?
She was employed by us as a jail lieutenant.
Okay. And so you had knowledge of her both as the sheriff and as the chief deputy?
Correct.
Okay. Did you supervise her at all?
Yes.
Okay. What was her position, if you know?
Jail lieutenant.
Okay. Is it sometimes called jail administrator?
Correct. It could be called that. Her title is jail lieutenant.
And did she hold that throughout the time you were chief deputy and sheriff?
Yes.
Okay. Was there any time she stopped being the chief deputy? Or sorry, the jail lieutenant?
Yes.
Okay. When was that?
In January.
What day, please?
I believe that was like the January, I'm not sure, 19th or 22nd, around there.
Okay. And are you the appointing authority for the sheriff's department?
Yes.
Okay. And I understand that to mean that you have the ability to hire and fire. Is that your understanding?
Correct.
Okay. And at this time, Ms. Lavasseur was an employee of the sheriff's department or something else?
I didn't understand what you said.
Was she an employee of the sheriff's department?
Yes.
Okay. And did you terminate her?
Yes.
Okay. Now, I guess, was she terminated from as jail lieutenant?
Yes.
Okay. And then was she then also terminated as correctional officer?
She was terminated as jail lieutenant.
Okay. Can you answer my question, please?
I guess I don't understand it. Her title was jail lieutenant.
Sure. Was she ever terminated a second time?
No.
Okay. So she was only terminated, let's put it this way. When she was terminated on January 19th or 22nd, she was terminated from county employment altogether. Is that correct?
Yes.
Okay. When was the decision made to terminate Ms. Lavasseur's employment?
It was based on, we took the decision the following, after she left the building, we had offered her position of demotion to correctional officer. She refused to give us the answer, started making false accusations. We ended the meeting. As she left, I made a determination to terminate her.
Okay. Did you consult anybody when you made that determination?
I made that myself.
Okay. Can you answer my question, please?
I made that myself.
So is the answer that you did not consult anybody or something else?
No, I just relayed to Max Lindsay that I wanted to terminate her.
Okay. And again, that happened after a meeting with her, is that right?
Correct.
Okay. Now, did you meet with Max Lindsay at any time prior to meeting with Kim Lavasseur about terminating Kim Lavasseur as jail administrator?
Objection to that to the extent that it's requesting any privileged communications.
Well, when I'm asking him, I didn't ask him for the extent that there's of the communications. I asked him, did he consult with anybody at any time? He's already talked about that he instructed you, Max Lindsay, to terminate her. So now we're wondering what other conversations he had with you about this termination.
Well, conversations between Mr. Lindsay and Mr. Zupke would be protected. Certainly you can ask if there is conversations, but you can't get into the
well, not every conversation is going to be protected. So only those providing legal advice. So for example, a conversation between Mr. Zupke and Mr. Lindsay to terminate Ms. Lavasseur, that's not legal advice. So that would be not privileged, and that would be open, as he just explained already, it's apparently waiving that privilege. But even if that privilege, even if it wasn't a waiver, the rule still stands that that's not legal advice. So to the extent, and we've already raised this objection again before, and we need to be clear that Max Lindsay here is acting both as advocate and witness because he participated in these acts of termination.
Stop. What is your question?
What is my question? My question is did you consult with anybody else prior to terminate the meeting with Kim Lavasseur?
That question is fine. Go ahead and answer.
Sorry, repeat that again.
Did you meet with anybody prior to your meeting with Kim Lavasseur about the termination of Kim Lavasseur?
Yes, I met with the corporate counsel, Max Lindsay.
Okay. And at any time, was there a letter that was sent out to Ms. Lavasseur prior to your meeting?
No.
Hold on 1 second. We've got two people in the waiting room, and I don't know who they are. They're not in right now, but we have an iPhone 3 Cindy and a 715-292-0165. Who are they?
You know?
I am unaware.
Okay.
I don't know.
I'm just gonna ignore them because they don't need to be here.
It's not private.
All right, Mr. Hitchcock, cross continue.
Thank you. All right. And at any time, did you get copied a letter from Max Lindsay to Kim Lavasseur about regarding Ashland County Notice of Employment Action?
Did I get a letter from Max Lindsay, you said?
Mm-hmm.
For the notice of what? I'm sorry.
Regarding Ashland County Notice of Employment Action.
I believe that was given to Max Lindsay. Have given it to our county clerk.
Okay. Have you been copied on that email?
I'm not. I don't think so.
Okay. And do you read all your emails?
Yes.
Okay. So, Mr. Carlson, if you can show him what is our exhibit. We've marked it 230119, letter from Lindsay to Lavasseur.
You have a copy of it?
Yeah.
Okay, let me just quick make sure. Is it 20? What is it? 23-0?
Sorry, I don't have it on that one. It's 23-01-19, letter from Lindsay to Lavasseur, dash demotion.
Got it. So I'm going to mark this as Exhibit 2.
What was Exhibit
And
1?
Exhibit 1 is going to be that pre-trial or pre-hearing statement that was emailed to us earlier. Okay.
Great. Sir, do you see this document?
Exhibit 2 is in front of him.
Okay. Does this document help refresh your recollection as to whether or not you were received an email from Max Lindsay to Kim Lavasseur regarding Ashland County Notice of Employment Action?
I don't have a copy of this. I didn't receive that, but like I said, I was told it was given to our county clerk who keeps the records.
Okay, so I point you to the bottom of that document. Do you see that?
Correct.
Okay, and do you see your name anywhere on this document?
Yes. Yes.
Okay, and it says CC and then it has your name, right?
Yes.
Okay, so it's your testimony that it was never copied to you, that that's false, right?
I can't say for sure. Like I said, I get hundreds of emails a day. I may have gotten it. I'm not saying it's possible. Like I said, I may have been attached, but like I said, the county clerk is the keeper of the records. So why I didn't find it wasn't my prior list to say I should have a copy of it because I know the clerk keeps copies.
Okay, but you didn't read it as well, right?
If I did, I might have briefly, like I said, I'm not sure, remember seeing it. I get hundreds of emails a day. So, I mean, to say that the specific one I read over.
So I'm sorry, I didn't understand that answer. Have you seen this document?
I don't recall, like I said.
You don't recall, I understand. Now, do you know who Ant, Wickman, and Lindsay are?
Correct, yes.
Okay, what is their connection to Ashland County, if any?
Max Lindsay's our corporate counsel.
Okay, so do you recognize this document as a document created in the normal course of business for Ashland County?
I guess I don't get the question. Like, do I recognize it? Have I seen it before?
No. Is this the kind of document that Ashland County sends out during its normal course of business?
In this specific scenario, I'm assuming that would be done every time.
Okay. And again, you recognize the law firm that sent this letter out as the corporation counsel, right?
Correct.
And in fact, the person who authored this, Max Lindsay, the person who's sitting next to you here now, is the person who authored this letter, right?
Yes.
Okay. Now, in this letter, it says, and I'm going to read the first paragraph, in my capacity as corporation counsel for Ashland County, this letter is to provide you with official notice that the county has decided to remove you from your current employment position as jail administrator effective immediately. Did I read that right?
Yes.
Okay. And you testified earlier that you are the one who makes the employment decisions for the sheriff's department, correct?
Yes.
So you made this decision, didn't you?
Yes.
Okay. So it also goes on to say you may continue your employment with Ashland County in the position of correction officer in the Ashland County Jail, correct?
Yes.
Okay. And you made that decision as well?
Initially, prior to my meeting with Lavasseur, the day she was given her paperwork.
Okay. So again, both of these decisions, and I appreciate that for anticipating my next series of questions, both of those decisions were made to you prior to the writing of this letter, right?
I made the decision prior to our meeting with her.
And prior to the drafting of this letter, correct?
Correct.
Okay. And did you tell Max Lindsay to write this letter?
Correct.
Okay. When did you tell him to write the letter?
I couldn't say a specific date. It was before the meeting.
Okay. So then again, based on that testimony, these decisions here reflected in paragraph 1 were made before the letter was sent and before the meeting with Kim Lavasseur, right?
Correct.
Okay. Now, I'm going to point your attention to the second paragraph. You see that there?
Yes.
Okay, and the ultimate sentence of that paragraph reads, please meet with Sheriff Zupke as soon as possible today to return these items and to discuss your continued employment status. Do you see that?
Yes.
Did you direct Mr. Lindsay to communicate that to her?
Yes.
Okay. Did you plan on, did you coordinate the timing that Max Lindsay gave this letter to Kim Lavasseur?
Yes.
Okay. So then when you, how long between Max Lindsay giving this letter to Kim Lavasseur did you then meet, did you call Miss Lavasseur to meet with you?
Within minutes, she had returned to her office. I called her office and told her, please report to my office.
That was prearranged, right?
Prearranged for her to meet with me?
Right.
Yes.
Immediately after you
Yes.
met with Mr. Lindsay, correct?
Yes.
Okay, or sorry, that she met with Mr. Lindsay, just for the record. Okay. So was there anybody else in that meeting with you other than Miss Lavasseur?
Yes.
Okay, who was that?
Kyle Cadet.
Okay, and did he know about that meeting prior to attending the meeting?
Yes. I asked
And
him.
did he know the reason for the meeting prior to attending the meeting?
Yes.
Okay, because you told him or something else?
What was your last part? What did you say?
Because you told him the reason for the meeting or something else?
I told him the reason for the meeting.
Okay.
I'm sorry, that was with who?
Kyle Cadet.
Thank you.
And just for the record, what's his position?
His position was detective, or is detective.
Okay, and now what is his position?
He's interim jail lieutenant.
Okay, and jail lieutenant, that's the position that Miss Lavasseur formerly held, correct?
Yes.
Okay. When did you tell Mr. Cadet that he would be the interim jail administrator?
Objection to this, to the relevance of the scope of this hearing.
Overruled.
Okay.
So I can answer.
Yes.
So basically, I'm not sure the exact date. It was between the meetings and whatnot. We decided for the demotion. So I would say a few days prior, I asked Kyle Cadet to be interim jail lieutenant.
Okay, so prior to Mr. Lindsay giving the letter to Miss Lavasseur, both you and Mr. Cadet knew that Miss Lavasseur was going to be demoted, correct?
Correct.
Okay, but Miss Lavasseur did not know that she was going to be demoted, right?
Prior to that date? No.
That's right. Okay. And this letter, was there any other communication from the sheriff's department to Miss Lavasseur other than this letter before you explaining to her that she would be demoted or removed from her current position as jail administrator effective immediately?
No.
Okay. Now, did you record this meeting that you had with Miss Lavasseur?
Yes.
Okay. Why did you decide? And I assume that you decided ahead of time. I guess I'll ask that without leading here. Did you decide to record this meeting ahead before the meeting?
Before what? I'm sorry, I didn't hear you.
Before, did you decide to record the meeting with Miss Lavasseur before the meeting with Miss Lavasseur?
We still didn't hear you.
I'm sorry, I'll say it a third time. The meeting with Miss Lavasseur that you recorded, did you decide to record it before you met with her?
Yes.
Okay. And did you personally record it or somebody else?
I did.
Okay, why did you decide to record this meeting?
To maintain credibility. I also have another person in the room as a witness as well.
Okay, what does maintain credibility mean?
The truth.
Okay. And you were concerned that the truth, somehow the statements that came out of that meeting wouldn't be accurately reflective of the truth. Is that what I understand?
Correct.
Okay. Why did you believe that? That might be the case.
Well, my experience as an employer, some employees react differently and don't interpret it the same way that myself or the majority would.
Okay. Upon becoming sheriff, had you received any training and discipline at the Ashland County Sheriff's Department?
Yeah, I've been a few supervisor trainings.
Okay. And did you learn about pre-disciplinary hearings at any time?
Pre-disciplinary hearings.
Correct.
I mean, various topics. I mean, basically, I mean, can you elaborate what pre-disciplinary hearing is?
Okay. So it's fair to say your understanding of pre-disciplinary hearings is evolving at the current time?
Object to that misclassification of any testimony that, to the extent there was any.
Just re-ask a question.
Yeah. And I don't mean to speak for you, sir. So I apologize if that sounded like that. I understood you to say that you were in the process, or that there was, it didn't seem like your knowledge of the subject was complete. Did I understand that part right?
I mean, I understand what you're saying as far as pre-disciplinary hearings, whether write-ups or warnings. I'm fully aware of how the process works.
Okay. And when did you first become aware of how the process works?
Ever since I've been a supervisor.
Okay. And was that when you were the chief deputy or even before that?
I was a sergeant detective for
throughout that process, while you were sergeant detective, did you ever conduct a pre-disciplinary hearing?
If I conducted one, no. Was I trained in on it? Yes.
Okay. Was there any time that you ever conducted a pre-disciplinary hearing?
As far as writing people up, yes.
Okay. How about for demotions?
No.
Terminations?
I've been involved with termination.
Okay. And was that while you were the chief deputy or something
Yes.
else?
Yes.
Okay. So is it fair to say that while you were the chief deputy, you observed the sheriff conducting pre-disciplinary hearings?
Yes.
Okay. Are there any policies and procedures at the sheriff's department for conducting pre-disciplinary hearings?
As far as policies, I mean, there is, I mean, we have SOPs in place where how the write-ups work, forms to be used.
Okay. And do they talk about those policies and procedures talk about pre-disciplinary hearings at all?
To my knowledge, as far as talking about, like, I mean, what do you mean? What are they talking about? Like, it's.
Well, we can just get to the cut to the chase here, I hope. Is your knowledge of does the policy and procedure include that pre-disciplinary hearings are to occur before discipline or pre-discipline?
Not necessarily. No, it doesn't.
Oh, okay.
Based on, I mean, not every discipline is the same. It could be a egregious thing where you can bypass all those.
Okay, so there's some things that are so egregious where you don't have to give the employee notice of the decision prior to the decision. Is that fair to say?
Yeah, I mean, if somebody committed murder, I'm not going to write them up for a warning.
Okay, and does your knowledge of what a pre-disciplinary hearing only include a warning?
There's warnings, there's suspensions, there's leave without pay.
And I don't mean to, I'm wondering here if when I'm saying pre-disciplinary hearing, you're meaning progressive discipline, meaning you don't necessarily fire right away. You go up sort of the chain of progressive discipline from suspensions to progressively increased suspensions to then possibly termination. Is that fair?
Depending on the scenario, yet again, like I said,
Okay.
how egregious is the act?
By pre-disciplinary hearing, I'll submit to you that is a hearing that occurs before the imposition of discipline, whether it be termination, suspension, a write-up, or anything along those lines. Is that definition acceptable to you?
Yeah, I mean, you're explaining the process, yes.
Okay. Are there any policies, procedures in Ashland County Sheriff's Department that account for such a pre-disciplinary meeting?
They require it? No.
Okay. And how do you know that?
How do I know that?
That's right.
Policy. The policy, like I said.
Okay. And you've read them all?
Read the majority of them. We have quite a bit.
Okay, appreciate that. Now, there's this meeting that you had that was prearranged between you, Mr. Lindsay, and Mr. Kadat with Miss Lavasseur present, right?
What was your question?
You had a meeting on January 9th with 19th, thank you, with Miss Lavasseur. I'm just trying to focus your attention back to this meeting here. Mr. Kadat and yourself, that was prearranged with Mr. Lindsay, right?
Yes.
Okay. And then at that meeting, you invited Miss Lavasseur to resign, correct?
That in that meeting?
Yes.
No, there was nothing said in that meeting about resign. Well, I said I said it was an option in the meeting. Basically, she was asked repeatedly about the demotion, said she could not give an answer. She didn't want to answer it.
Okay, but the decision to demote had already been made, right?
For demotion, you said?
Right.
Correct.
Okay. So the purpose of that meeting wasn't to discuss the demotion, was it?
Yes, it was.
Okay, but again, the decision to demote had already been made, but prior to that meeting, right?
Yes.
Okay. So that left the question of whether Ms. Lavasseur would either resign or accept continued employment as a correctional officer, right?
Yes.
Okay. Was a decision on that made during that meeting?
No, there was no decision made by Ms. Lavasseur.
Okay. But at that time, the option was still available to her, correct?
Well, during the meeting, it turned into accusing myself of something that was false. And then so I ended the meeting. It was getting elevated with whether or not what was said or what wasn't, which was inaccurate. So I ended the meeting. I didn't think it was going in the right direction. And after the meeting, like I said, she was escorted out. I made a determination that the lack of admittance on her part of fault in not giving us an answer on the job, I chose to terminate.
Okay, and that occurred after the meeting, right?
Correct.
Okay. Great. Now, when you said walked out, what did that mean?
She was, Kyle Cadet escorted her to her office to get her belongings, and she was escorted out the building.
Okay, and why did that occur?
Because at that time we were unaware of where this was going, and I think the lack of trust at that point in time, it was best opted to escort her out.
Okay, now at any time after that meeting, was there any communications? I guess let me put it this way. So when she left that meeting, she was no longer the jail administrator, correct?
Correct.
Okay, and you had walked her out of the building, correct?
Kyle Cadet walked her out of the building.
I'm sorry, the sheriff's department removed her from the building, right?
Kyle Cadet walked her out of the building.
The sheriff's department member, right?
He's an employee of the sheriff's office.
Great. And he did so under your orders, right?
Correct.
Okay. So, what would have happened at that time had Miss Lavasseur tried to return as a correctional officer and return to the sheriff's department?
Look, what do you mean, like return physically or?
Right, return
work?
physically. What would have happened at that time after she had been walked out if she had returned physically to the sheriff's department? We'll stick with that.
At that point in time, I mean, she was not allowed back in the building.
Would she have been arrested?
I can't forecast about what would have happened if something that didn't happen.
But she was subject to arrest, right?
She was.
Objection to that. Calls for speculation and misclarifies the witness's testimony.
Okay.
And I gotta sustain that. I don't know what the relevance is. I
feel we're getting far afield as well, so I can accept that feedback and we'll go in another direction here. So, after she was walked out, did you have any communication with Kim Lavasseur at any time?
No.
Okay. Did she email you at any time?
Yes.
Okay. And you understand email to be a form of communication, right?
Yes.
Okay. And then did you respond to that email?
Yes, I said refer all your questions to corporate counsel.
Okay. And what did she ask you about?
She wanted to know the details of her return to that job, the correctional officer.
And did you make your decision to terminate her before or after she asked you that question?
At that point in time, I was contemplating it. And like I said, I think I woke up fresh minded the next morning, was 100% sure she was terminated.
Okay. And this is on the next morning, of course, and this would have been Friday, the January 20th, right?
Correct.
Okay. So when you respond to her on Friday, January 20th at 10:32 a.m., saying, Kim, please refer all questions to Max Lindsay. Thank you, Brian. You had already made the decision to terminate it, correct?
Again, like I said, I slept on it overnight, like I said, and woke up with the reasoning of.
When do you wake up in the morning?
Like that morning, I don't know, it can vary.
Okay. But again, the first thing you did that morning was not to email Kim to go refer her questions to Max Lindsay, right?
I'm not sure what time I responded to her. I just said refer questions to corporate counsel.
Okay. Then we'll just be clear on this. Did you respond to her before, after, direct her, to refer all of her questions to Max Lindsay before, after you personally decided to terminate it?
Like I said, I don't know the time on it, so
okay.
I can answer that.
No, I understand. Thank you. And then when you said, did you at any time explain to her why you were terminating her?
Did I explain to her?
Yes.
No.
No. Okay. Now,
well,
and again, like you said the reason that I don't want to put words into your mouth. Please remind me what the reason that you terminated her for on January 20th. What the reason that you decided to terminate her for on January 20th was?
The lack of action for 2 months of 2 male inmates having sexual activity and assaults in our Ashland County Jail.
Okay. Now I understand. So, and I just want to make sure my notes are right. You said 2 months of inactivity with sexual assaults at the Ashland County Jail, right?
Yeah, no proper investigation, no discipline by anybody, and no proper separation of the two immediately.
Okay. And that's when you
violations were occurred too as well. Jail rules of 2 inmates that aren't housed together were in the cell together every day. Of the 2 inmates that were having the sexual activity, the uniforms and towels were put up to block view of the jail cell every day for these 2 months.
Okay. And that was while she was the jail administrator, right?
Correct.
And that was also the reason that you removed her as jail administrator, correct?
Correct.
Okay. And I just want to take you back a few minutes because I think you said that something was said during this meeting that you had with Ms. Lavasseur and Kyle Kadat that was not true. Did I remember that right?
I didn't, something was said what?
There was something untrue that was said, I think, by Ms. Lavasseur that you were saying that occurred in this meeting.
Yes.
What was that she said that was, or maybe it was false accusations, and now looking at my notes. Does that refresh your memory?
Yes.
What were the false accusations that she made?
She told me that I was told about this incident. I said, no, I wasn't. And she said I had a bad memory.
Okay, and it's your testimony here today that you were not told about this incident prior to this meeting on January 19th of 2023?
Objection, no, that was not his testimony.
Just restate.
Well, then he can answer the question. No, that's the easy way to solve it.
Hold on, restate your question, please.
Okay. So is it your testimony that you did not have knowledge of the sexual assault allegations? Oh, I guess I put it that way. When did you have knowledge of the sexual assault allegations? No, I see that, and fair enough, Max, I get it.
The knowledge, I believe it was November 29th. I was confronted.
Of 22?
Yes.
Okay. And it's your testimony today. You said 9th as in November 9, 11/9. Is that right?
29th.
2/9. Okay, so 11/29. I got it now. So this is some month prior to being the sheriff, right?
Correct.
Okay. And this is before or after the election?
After.
Okay. And so you're saying that her, and I guess this is what we need to be clear on. You say that she was, her accusation that you were aware of the sexual assault allegations prior to 11/29 was false. Is that right?
Where prior to November 29th, you said?
Right.
Yes, that's correct.
Okay. And I guess another way to ask it is that's a fair summary of what the accusation of you. That's a fair statement on what you're saying is false that she said.
Yes.
I hope that was confusing, right?
Yes.
Okay, great. And so do you have access to a phone at the present time?
Yes.
Are you texting anybody?
No.
I can tell you that I can see his hands. There's no phone in his hands.
Okay. It's I'm at a weird angle and I'm quite above you, so I guess it's hard to see, but I appreciate that. So, do you know when Ms. Lavasseur was given the letter terminating her employment from the county as correctional officer?
I don't know the date. Corporate counsel had handled that.
Okay, but it was sometime after the 20th?
Yes.
Okay, and when did you tell the corporation counsel to write that letter?
Like I said, that day I said to terminate.
Okay, and did you
I
consult
mean, the day after the meeting.
Did you consult anybody in regard to that?
Hold on. I want to get a date so I get my timeline right.
Sure.
The day after my meeting with Lavasseur was on the 19th, I believe. So the 20th.
20th?
Yeah.
Thank you.
Okay. So I'm going to show you here what's labeled 230120 email between Lavasseur and Zupke.
Okay, so this is gonna be exhibit 3.
Great.
Copy, you can confirm this is correct, John.
Let me just make sure it's what I just put into the folder. You said 120?
It's the next one down in our folder here. 23-120 email between Lavasseur and Zupke.
Yeah, hold on. We got the wrong one.
It says forward employment status.
Do you have a copy of it?
Yeah, that one is also labeled email between the rest of these. Yep. Is that the right one?
Okay, that's it. Okay, he's got exhibit 3 in front of him.
Great. And do you recognize this document?
Yes.
Okay. And this document contains an email that Kim Lavasseur sent to you on January 19th at 10:41 p.m. And she asked about your offer. She said she would like to discuss via email my continued employment status. You state that you would like me to remain as a correctional officer. What are the conditions of this officer? Did I read that right? That's at the last page there at the bottom.
Okay, I see it. Okay.
And it's in a smaller font. Do you see that?
Yep.
Okay. And did you receive that email, right?
Yes.
Okay. And it was after she sent you that, in fact, the next morning that you decided to terminate her, correct?
Correct.
Okay. And again, you never had any pre-disciplinary meetings between this email here on January 19th of 2020 at 10:41 p.m. and when you emailed or communicated with me, sorry, when you came up with the concept of fire or made the decision. I want to ask that again, and I apologize. You did not have a pre-disciplinary meeting between January 19th at 10:41 p.m. and the next morning in which you decided to terminate Ms. Lavasseur's employment, right?
A meeting with who?
Ms. Lavasseur.
No.
No. Okay. And again, at 10:41 p.m., Ms. Lavasseur still, I guess, was she still employed by the Ashland County or no?
Let's see, I'm trying, okay, 19th, yeah. I mean, like I said, at that time, that day, that meeting, I woke up the next day and decided that morning. I don't know, I can't know the exact times when I called Mr. Lindsay, but it was determined the next day.
Great. And again, I just want to focus you back to the question I asked, which is on January 19th of 2023 at 10:41 p.m. Was Ms. Lavasseur still employed by the Ashland County Sheriff's Department or something else?
At that point in time, we didn't know because, like I said, she did give us an answer when we left that meeting.
Okay. So when she received the original letter from Mr. Lindsay on the 19th, she was terminated as an employee. Is that fair to say?
No, hold on. You guys are talking in 2 different paths here. I understand what you're saying, Attorney Hitchcock-Cross. You guys are not connecting though on what is being asked. So start over, ask the question and listen to the question carefully.
Great.
Otherwise, we're going to have 10 questions about the same thing.
That's never happened to me before. Let me ask you this, and we're going to slow down. Here's the key concepts that we're trying to compare, okay? Is that at a given time, what was Ms. Lavasseur's employment status, okay? So when Max Lindsay handed Miss Lavasseur the email or the letter saying that she was no longer the jail administrator? Was she employed by Ashland County at that time?
Yes,
Okay. How about after she received that letter?
she was offered the demotion to correctional officer, where she would still have been considered an employee if she accepted it. Then the meeting occurred.
Okay. So she was still an employee during the meeting.
Yes,
Okay. How about when she was walked out? Was she still an employee?
at that time, yes.
Okay. And was she still an employee at 10:41 p.m. when she asked you what the conditions that when she says you state that you would like me to remain as correctional officer, what are the conditions of the offer?
Well, she would have been considered, but like I said, if you read my response on the 20th at 10:32 a.m., when I probably viewed it, she was no longer an employee then because I made a decision already.
Okay, and that's
Most likely I would probably be sleeping at 10:41 p.m. when she emailed.
okay, I got it. But in the morning, so sometime between 10:41 p.m. and 10:32 a.m., she no longer became an employee of the department. Is that fair to say?
Correct.
Okay. But prior to that, even though she was an employee, she was demoted. Is that also fair to say?
Yes.
Great. And when did the demotion happen? When she was handed the letter?
Yes.
Thank you. And who is Sue Misson, if you know?
He works for the county clerk's office.
Okay, and why would you be emailing her in connection with the jail administrator role?
Regarding what email?
Sure. And maybe I've got you confused with Mr. Grady. Oh no, I got it. So on January 23rd of 2023, were you copied on an email from Dan Grady about the jail administrator?
I don't have it in front of me. It's to say.
But you recall that email, right?
As far as an email to about what?
Did you review any documents in preparation for your testimony here today?
Excuse me?
Did you review any documents in preparation for your testimony here today?
Yeah, what documents are you asking about, I guess?
It's just yes.
Yes, I reviewed it.
Okay.
Viewed some documents.
Great. Okay. So again, and you read all your emails, but on Monday, January 23rd of 2023, do you recall being copied on an email from Dan Grady to Sue Misson and yourself talking about Kyle Cadat replacing Kim Lavasseur as jail administrator?
Yes.
Okay. And then, okay. And did you have any conversations with Mr. Grady at any time about Kyle Cadat replacing Jan Lavasseur as the jail administrator?
Yes, about interim jail administrator.
When was the first time you had a conversation or any communications with Mr. Grady on that subject?
I can't say a specific date. Like I said beforehand, we had to pre-plan for the demotion, so he was notified. Corporate counsel was.
Okay, so you also conferred with Mr. Grady prior to demoting Miss Lavasseur.
Correct.
Did he have any comment on that decision?
We talked about several scenarios.
What were those scenarios?
Termination, demotion.
Okay, those are the two scenarios.
Correct.
Why was it decided between you and Mr. Grady to ultimately demote?
Well, I made that decision.
Okay, and I appreciate that distinction there. Where were you when you made that decision?
I don't know.
Okay, was it prior to meeting with Mr. Grady or after?
I couldn't say. Yeah, like I said, it could have been after.
Okay.
I'm pretty sure it was after.
Okay. And if there's a recording of you saying that there's people in the county who say that Ms. Lavasseur should be terminated, who would that be referring to?
Like I said, I spoke with Mr. Lindsay, and when I say people are saying, I says people are saying I have enough reason to terminate. When I was seeking advice from corporate counsel, Mr. Grady, basically due to the egregious incident, it was determined that there was more than enough to terminate.
Okay. And again, this is all prior to this January 19th, right?
Correct.
Okay, and because I need to be clear here, you were only the sheriff for 16 days at that point, right?
Correct.
Okay, so how soon into becoming sheriff did you make this decision to demote Ms. Lavasseur?
Demote.
Demote.
Like I said, I can't give a specific date. It was prior to the meeting. Wasn't long before I made the decision to demote her as correctional officer.
Okay, so that happened before. So in fact, it's less than 16 days because it happened well
Yes.
before the 19th, right?
What's that?
The decision to demote Ms. Lavasseur happened far less than 16 days between the day you were appointed, you became sheriff, right?
Yeah, just like I said, I can't give a specific date. It was prior to my meeting with her. Wasn't
Right,
long,
but you,
long
and you
before.
testified that you told Mr. Kadat at least 3 days ahead of time that he was going to replace Ms. Lavasseur, right?
Like I said, I don't know a specific date. Even my conversation with Mr. Kadat, there was no exact day. I told him prior to that, we would need somebody as interim.
Okay, and did you tell that Mr. Kadat, did you tell Mr. Kadat that he would replace Ms. Lavasseur before or after you met with Mr. Grady?
I don't know. Like I said, I don't have specific dates of all those meetings.
Okay, but you made the decision after, or I guess you weren't clear on that either. Okay, I got that. So, and just for the record, who is Mr. Grady, if you know?
County administrator.
Okay.
So just so I'm clear, just to clean this up. When between taking office as sheriff January 3rd and your meeting with Kyle Kadach and Ms. Lavasseur on the 19th, did you decide that you're going to demote her as jail administrator to correctional officer?
I mean, I can't say specifically. There was meetings taking place. I want to say within a few days prior. It was determined that I'm not sure which day that we were going to demote her. I spoke with corporate counsel and said this was my decision to demote, and I don't have a specific date when that occurred, but it wasn't long before our meeting.
I understand what you
Understand.
I think that maybe for the sake of efficiency, if we can just take a brief 2-minute break here, I'm going to consult with my clients and we may be close to being done. Will that work?
Yeah, that's fine. Let's take 5 minutes, and then if you're done, I'd like for Mr. Lindsay to be able to go through his testimony with Mr. Zupke so that we don't have to recall him. Makes it a little bit more efficient.
Sure, I don't disagree with that in principle. Great. We'll be right back.
I'm going to step out and we can mute this so that Mr. Lindsay can talk to Mr. I don't know how you guys are gonna have to-
Well, no, you can't talk to the witness you can't talk to the witness while he's on the stand. I mean,
well,
that's not fair.
Not about content, but I mean, you can talk.
Like baseball or.
Oh, we did just have some nice weather. So yeah, I agree with what you're saying, but let's just.
Well, normally we err on the side of caution, have them sequestrated, but I understand this isn't that.
We're not doing sequestration.
No,
You're talking
we're
about testimony. You understand?
Yep.
Yes. Fair enough.
I have to go use the rest.
That's whatever.